Hi, this is Kelsey Fukowski for AP Gov Review, and in Unit 6, Part 3, we're now going to be looking at civil rights in public policy, not civil liberties, which of course come from the Bill of Rights, but civil rights. So let's first start off by defining what is a civil right. So these are policies designed to protect people against arbitrary or discriminatory treatment by government officials or individuals. The main theme really of civil rights is equality, that the law has to be enforced equally. And when it's not, that becomes a civil right. And typically where you begin to look at the topic of civil rights, we're going to be looking most notably at racial discrimination as well as gender discrimination. And gender discrimination certainly is an issue that's been an issue, as you'll see, in the 1970s and 80s, and some even argue today. But discrimination also takes all different types of forms based on age, disability, sexual orientation, as well as other factors. So a civil liberty, just to distinguish it from a civil right, a civil liberty is, let's say, voting, your right to vote. However, when someone of a particular gender or ethnicity has had to fight for one of these liberties, such as the right to vote, this is now considered a civil rights matter. Again, think equality with civil rights. Now, when we look at conceptions of equality, equal opportunity equals same chances. And that's sort of ingrained into the United States' political culture, if you recall, into Unit 1, where every country sort of has its own unique political culture. And in the United States, equal opportunity is part of the political culture. Now, equal results, on the other hand, is not necessarily part of the United States' political culture, where you have the same rewards. So the Constitution and inequality, nothing is not even mentioned about equality. You can't find it anywhere in the original Constitution. It first is actually going to appear in the 14th Amendment. The 14th Amendment is the amendment of Unit 6. You have to know that it is the Equality Amendment in so many ways. Without this particular amendment, you're not going to have Unit 6 in civil rights. Because it contains the Equal Protection Clause, otherwise known as sort of the Due Process Clause. And when we look at equal protection, it means that the law has to be applied equally. The law cannot be applied one way for one group of people and a different way for another group. So in many ways, the 14th Amendment is the most important amendment of all the amendments that we have for the civil rights movement. Now, keep in mind that while typically discrimination is thought of wrong, and it typically almost always is, not all discrimination is wrong. And before you say, wait, what are you talking about? Let me give you a couple of examples. So there are three main standards of review. First one is reasonable, and this is a very easy discrimination test to pass. So for example, if you think about it, if you're not over the age of 18, you are being discriminated against. For example, you cannot vote until you're 18. Another example, you cannot drive until, in many states, you're 17, or with a learner's permit, 16. So if you have something reasonable, and again, it's reasonable to discriminate against you, because do we want 10-year-olds driving a car? Probably not. Now, there are other ways that you can be discriminated against. It can include wealth as well. I mean, there are a number of different factors here, but these are very easy in terms of the standard of review, in terms of whether or not it is allowed. Now, when you're dealing with intermediate scrutiny, we're talking about things like gender, and this is very difficult. It must meet a substantial relationship to government purpose. Again, very, very difficult, moderately difficult to meet. And then the next one that's even tougher deals with race. And this standard of judicial review is inherently suspect, almost impossible to meet, because it's dealing with race and ethnicity. And based on the Civil Rights Act, based on the Due Process Clause and the Equal Protection Clause, it makes discrimination on a legal basis very, very difficult. So again, just to reiterate, you have three standards of review with discrimination. If it's dealing with something like age or wealth, you're going to utilize the reasonable standard test. If it's dealing with gender, you're going to be using the intermediate scrutiny test. And then the most difficult test to pass is the inherently suspect test. So when we look really at the history of race and public policy, and if you're familiar with U.S. history, Certainly you're going to remember the Dred Scott v. Sanford case in 1857, just a few years before the Civil War starts. It invalidates the Missouri Compromise. Slaves have no rights. And then following the Civil War, you're going to have the emergence of the 13th Amendment, which is going to outlaw slavery, followed by the most important amendment being the 14th Amendment, granting citizenship to blacks and reversing the Dred Scott decision. So really when you look towards racial equality, 1619, you have slaves coming into Jamestown from Africa, and it takes you all the way up to 1865 just to abolish slavery. And just because you've abolished slavery does not mean you've made former slaves equal. So certainly you had that era of Reconstruction, which is seen largely as a failure, as you have the era of Jim Crow or segregation laws coming about. Many businesses and individuals did and legally could discriminate. You also had, at the turn of the 20th century, Plessy v. Ferguson, which is going to uphold equal but separate accommodations. And you'll find that interesting that you see Plessy v. Ferguson in an AP Gov course, and if you take an AP US history, that's certainly a very important case. If you have a good, solid American history background, you're going to be very well set for Unit 6. And then when we get to the presidencies of FDR and Truman, as we know, this will desegregate areas of the government. And again, following the Civil War up until 1950, right, you see a lot happening where you see the fight for civil rights really coming to the forefront. And this doesn't even include the era of the 1960s on that particular chart. So the era of civil rights, certainly the hallmark case that you should definitely know about is Brown v. Board of Education in 1954, which is going to reverse the previous Supreme Court case in 1896 of Plessy v. Ferguson. And this is where you have the NAACP and Thurgood Marshall. And remember, the NAACP is an interest group fighting for African American rights. And remember, we say the last resort for interest groups tends to be the courts. And certainly they had a very favorable court, as the Warren Court, this is very important to know, was seen as being a very liberal court. And as a result, this is going to make school segregation inherently unconstitutional, although it will take some schools nearly a decade to actually desegregate. But it was supposed to integrate schools with all deliberate speed, nevertheless. This also is going to take care of busing of students' solution for two kinds of segregation. You have de jure by law, so it's ending legal discrimination, but also you have de facto discrimination, where you had at this point African Americans living in one neighborhood, maybe because of financial constraints, and then you had wealthier people who tended to be white living in another neighborhood, and they're going to different schools. Now that you're busing them together, you're sort of ending this segregation by forcing this integration coming in. So it certainly solves that issue. Also important is the Civil Rights Act of 1964. This is going to make racial discrimination illegal in hotels, restaurants, other public accommodations, especially any place that did interstate business. Note that, restaurants can do interstate business, hotels can, many public accommodations do. This is also going to forbid employment discrimination based on race. Again, as much as you can enforce this. It's on the books, but in reality, of course, you still had it going on. It's also going to create the Equal Employment Opportunity Commission, which is still in existence today, and this is going to strengthen voting right legislation. And a court case that comes out of it is the Heart of Atlanta Motel versus the United States, in which Congress could use the Commerce Clause to force private businesses to abide by the Civil Rights Act of 1964. Remember in Unit 1 where we talked about really the Commerce Clause to some extent doesn't really have to do with all that much with commerce as it does with giving basically Congress the power to regulate almost anything. In this case, it's going to come in handy with the Civil Rights Act of 1964. And if you remember from Unit 1, the one case where Congress really stepped too far was that U.S. v. Lopez case, where, of course, Congress was trying to restrict illegal guns in school zones. And, of course, the court was going to say you went too far. But in this case, you're going to see the Heart of Atlanta Motel v. the United States allowing the Commerce Clause to force businesses to abide by the Civil Rights Act. And in this chart, you see the percentage of blacks attending schools with any whites in southern states dramatically increasing. You see that following Brown v. Board of Education significantly. And then, of course, you have the issue over suffrage. Suffrage meaning just the legal right to vote. And the 15th Amendment does extend suffrage to African Americans following the Civil War. Of course, you did have poll taxes, which is going to really affect many of the former slaves because they're not going to be able to vote. You also did have white primaries. Only whites were allowed to vote in party primaries. So that's a major issue, and that's going to be a roadblock. However, the 24th Amendment is going to eliminate poll taxes for federal elections. So that's a very important amendment to know in terms of that. And then you also have the Voting Rights Act of 1965, which the government could not deny an individual the right to vote based on race or color. And this makes literacy tests illegal. For many people, if you're unable to read or write, especially read in this case, you would not be able to vote. And the federal government also utilized election inspectors as well to ensure that. So let's do a review question here. Discrimination in public accommodations was made illegal in the United States as a direct result of take a moment if you have to pause your screen for a second. And if you said the Supreme Court decision in Brown v. Board of Education of Topeka, you are correct. And kudos to you.